Hello, everybody. It's your friend Rick. It is December the 31st, 2017. If you need to reach me by email, I do not do phone calls, sorry. Uh, my email is rick, R-I-C-K, 0327 at me.com. If you need to reach me just because you would like to make a donation to receive my paperwork and you want to know what you're getting for the donation. Okay, I'm sorry, I don't do question and answer stuff. Okay, I get a lot of emails. I'm sorry. Um, just watch my videos, and obviously I'll answer questions if you're looking to make a donation to receive paperwork. I don't expect you to send me a donation, without me telling you what you're going to get. Okay, what you're getting is my paperwork and with instructions, and obviously I'll answer, questions related to the paperwork and your fight. Okay. All right. All right, this video is we're going to discuss a constitutional right that we have, okay? And you could file it in court. And what's good about this is that because it's a constitutional right, it cannot be taken away from you. And if it is taken away from you, you have a recourse, okay? Not just like an objection, you could file a trespass uh, for trespass upon rights, deprivation of rights under 42 USC, 18 USC, and it has to be answered. Okay, the courts are getting away with this stuff because they don't like answering questions about why they're allowing you to be deprived of your property without the proper due process, because the child support benefits the state, okay? And the money for child support goes into the state treasury. And the laws have said that they're allowed to do whatever they want with that money. So remember, child support does not benefit the family. It benefits the state. So all child support proceedings established under 42 USC 650. Great. Wasn't that great? My text message I have from my aunt. Any child support established under 42 USC 654 subsection 3 does not benefit the family. The money goes to the state. So what they do is if a parent is applying for public assistance or is receiving public assistance, they want you to assign your support rights to them, which is basically illegal. Okay, that's where that way they can claim that it's support hearings, but the money's going to the state. So how is that child support hearings? It's really welfare recoupment hearings. Okay, it's nothing but BS. Okay, so let's move on. What we're going to do here is I'm going to show you some court decisions from the Supreme Court and a couple of state courts that prove that we're allowed to do this. Okay, and lawyers would never do this for you because they're not allowed to help you win a case in a timely fashion. Their goal is, well, first of all, they work for the state, they work for the court, they don't work for you. Think about how this works. Child support hearings really aren't for child support. Lawyers represent you, but they don't really represent you. They're officers of the court. They're not officers for you. They're officers of the court. That means their first obligation is to the court. All right. It's nothing but it's nothing but a scheme. That's why I've always said you're better off by yourself. Trust me, you're not going to get a lawyer and you're not going to walk away without paying something. I don't know of anybody that's been successful with a lawyer. All right, so listen, here we go. All right, the Supreme Court has said the following about a certain weapon we can use. Oh, come on, here we go. Come on, here we go. An important check on the manner in which state courts pay respect to federal constitutional rights. The blank is the fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Are we going against arbitrary and lawless state action? Yes. Arbitrary is an action it's not based on anything. There's no evidence. How many of you got a support order doesn't say anything about evidence? Doesn't say, based on the evidence introduced by the petitioner, the court finds. What the court usually does is says the findings of the court, but they never say what the findings are. Okay? All right. Therefore, the blank administered with the initiative and flexibility essential to ensure that miscarriages of justice within its reach are surfaced and corrected. Well, the blank, what we're talking about, is essential to ensure that miscarriages of justice within its reach are surfaced. That means miscarriages of justice, the courts are there, they're supposed to fix miscarriages of justice. So when you point out that by using what we're using, the court's duty is to correct it. All right, so that's why we're going to use it. We're going to force them. All right, it comes to us from the Magna Carta and is also commonly referred to as the poor man's lawyer. Right, we talked about this a couple of days ago. It is actually a complaint at law and embodies a demand to show cause for the respondents. In this case, the government. All right, the government, the child support agency, or the court. All right, who inflicted you with these arbitrary and illegal acts against you? The government, which is usually the petitioner, and the court and the judge. All right, to answer each and every issue contained in it. Thus, it is intended to force the state to answer why the superior law, which is the supremacy clause, under Article 6, Section 2 of the United States Constitution, does not override states' claims. There are plenty of laws out there created by state legislators who are elected by us, and here's the sad part. Most politicians are lawyers, which is a very bad thing. There was a law, the 13th Amendment, the original 13th Amendment was created to prevent lawyers. Now, back in around 1812, there were theories out there that the War of 1812 was really started because of the 13th Amendment, the original 13th Amendment, because the lawyers were prevented from holding public office. Okay, and there are some state constitutions out there with the 13th Amendment citing it word for word. All right, and it says that lawyers who are really foreign agents are prohibited from holding state office, becoming a politician. And it disappeared. And then the 13th Amendment became the emancipation, freeing slaves. Crazy stuff. All right, so think about how important that was, because England invaded our country because lawyers represent the British Crown. BAR, BAR, British Accreditation Registry. But you won't get anybody to answer that question with a straight face. All right, let's move on. What is the weapon, and what has the Supreme Court stated about it, and what it does? A judgment of conviction obtained in violation of due process of law is void for want of jurisdiction of the court to enter such judgment. All right? Fay versus Neuer. You can use this to challenge a judgment of conviction in violation of due process. Blank is an appropriate means by which relief from confinement, all right, we're figuring out where I'm going now, under a void conviction may be obtained in the state as well as in federal courts. Blank will issue only where the petitioner has established a lack of jurisdiction for order of confinement, that he is otherwise entitled to immediate release because of expiration. How do we get here? All right. You know where we're going here? All right. Blank is a fundamental instrument for safeguarding individual freedom against arbitrary and lawless state action. Its preeminent role is recognized by the admonition in the Constitution that the privilege of writ, of habeas corpus, shall not be suspended. Okay? That's our secret weapon, guys. It's a writ of habeas corpus. And the courts would have you believe, and the clerks would have you believe, that it can only be used for somebody who has been physically confined in a jail cell. Well, that's not true. All right? And these decisions that I provided support that. They don't want you to know this, but it's our secret weapon. So if you've been deprived of a constitutional right, writ of habeas corpus is the way to go. Writ of habeas corpus really is a order to show cause. You know how difficult it is to get an order to show cause in a state court? Because the court does not want to answer for its actions. Judges do not want to have to correct an action. They'd rather have you suffer than fix it. Okay? Here we go. Look at this. Okay? Let's read it in red. Its ability to cut through barriers of form and procedural mazes. That's all of these stupid civil court procedures, and all the clerks would have you believe that you cannot file this unless you file an appeal first. You cannot file this unless you file that first, or you have to file an objection first. Okay? I have a couple people going through this right now. Hopefully they're going to write this down and look it up and cut and paste it and use. Well, actually, I sent them the updated version. Okay? All right? The very nature of the writ demands that it be administered with the initiative and flexibility essential to ensure that miscarriages of justice within its reach are surfaced and corrected, as Blackstone phrased it. Writ of habeas corpus is the great and efficacious writ in all manner of illegal confinement, not just physical confinement. If you're bound by an illegal court order and you may be found in contempt of it, you're confined. You cannot say no to it. But it's illegal. It's a void order. This is the way to go. Okay, 1 second. To provide a prompt and efficacious remedy of whatever society deems to be intolerable restraints. That's us. Okay. Now this is the Tennessee Court of Criminal Appeals. It is well established in Tennessee that the remedy provided by writ of habeas corpus is limited in scope and may only be invoked where the judgment is void or the petitioner's term of imprisonment has expired. Judgment is void. Okay? As the Supreme Court has repeatedly recognized, writ of habeas corpus is, at its core, an equitable remedy, not just for physical confinement or bodily restraint. Writ of habeas corpus lies to enforce the right of personal liberty. When that right is denied and a person confined, the federal court has the power to release him. It has no other power. It cannot revise the state court judgment. It can only release you. So what we do is, that's why what I have you guys do is you file a proposed order on the federal Rule 60B for a void judgment. You file this with the writ of habeas corpus. All right? That way the court could fix it right away. That way you're not even giving them a chance to think about it. Okay? Have we figured it out? We did it, right? I gave it away already. Article 1, Section 9. Dismissal of a writ of habeas corpus. Now listen, this is where I said to you earlier that because it's a constitutional right, they cannot just dismiss it. Because if they dismiss it, every day that you're under this order, you're being injured every day, every pay period. Every day you cannot go to the store, every day you cannot pay your bills is a day of injury. Okay? So, is a dismissal of a first writ of habeas corpus is a particularly serious matter, for that dismissal denies the petitioner protections of the writ of habeas corpus entirely, risking injury to an important interest in human liberty. Okay? They can't just dismiss it. They think they can. Okay? So the courts know this and will make it hard to file it in appellate court. It's important to let the clerk's office employees know what we know and that they cannot refuse to accept writ of habeas corpus paperwork unless they provide constitutional reasons. Meaning that, hey, has it been suspended? Writ of habeas corpus can only be suspended during wartime, all right, or martial law. The Supreme Court of the United States decisions that I've given you guys held that the writ of habeas corpus is not just a remedy against physical imprisonment. It can be used to challenge non-physical restraints of liberty, and clearly supports the petitioner's constitutional right to file a writ of habeas corpus in a court against restraints of liberty that is not physical imprisonment. All right. So what I do is, all right, clerk paperwork. You're going to submit this. Of course, there we go. There's a spinning wheel. All right. Comes now, your name is demanding the clerk of the court and the employees to accept all writ of habeas corpus paperwork from the undersigned affiant, you, and forward it to the appropriate court. Meaning, forward the writ of habeas corpus. The Supreme Court of the United States decisions below has held that writ of habeas corpus is not just for remedy against physical imprisonment, blah, 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 blah. We talked about this already. These are the case laws here, all right? So they're going to have to explain why they're refusing to accept your constitutional right, okay? If they refuse to accept it, they must fill this out, okay? What I've done here, this is another thing I've done. It's called the preemptive objection. And what you're doing is it's a preemptive objection because we fully anticipate the court to deny the writ of habeas corpus. Okay, we're being kind of wise asses here, but we have a right to. We're letting them know that we're aware that child support benefits the state and that the court is going to do everything in its power to keep us paying child support. All right? The state relies upon federal funds under Title 4D, 42 UFC 658. That's the incentive funds. And the undersigned is expecting this court to prevent the undersigned from prevailing, which would prevent the state to receive federal funds. Child support under Title 4D does not benefit the child or family, but benefits the state. Blessing versus Freestone. Okay? A denial of writ of habeas corpus is a serious act. It must be lawful. Because denial of constitutional protection will cause continual injury by a unconstitutional judgment that was created without due process that is clearly causing the restraint of the undersigned's liberty. All right? There we go. It just opened up. I'm telling you, when I do this thing, sometimes the computer does some strange stuff, boy. All right. This is the writ of habeas corpus, quorum non judice. All right. This is a case law. Very good. The writ of habeas corpus is a fundamental instrument of safeguarding individual freedom against arbitrary and state action. All right. All you got to do is show this to the clerk. All right. You guys can slow it down and read it. The 14th Amendment, Equal Protection of the Law Clause, protects the undersigned from any state laws that deprive guarantees in the Bill of Rights. Okay, so hopefully you've seen that the writ of habeas corpus is the way to go. I did a video last week and I didn't get a good response. I guess it was too boring for you guys. All right, but this is the way to go. All right, you don't hear much about it. And let me show you this. This is a good channel to go on. It's called the Lawless Family Courts. He hasn't put out a video in a long time, but this guy, Excellent videos, very, very brief videos, okay? And we'll say everything that we're doing. This guy, there's a channel, where is it? Right here. Again, whenever I'm doing videos, the internet's very slow. And it's this channel here, Fathers Unite. And they say it also that the writ of habeas corpus is the way to go to fighting child support orders, really the same thing, jail support orders, child support orders, okay? So this is the way to go. They say it as well, okay? So I'll leave this link in the description, okay? But that guy, go to that channel. They're very brief videos, excellent videos, and it'll help you, okay? Also, writ of habeas corpus can be granted for custody. Those of you that are having problems with custody, writ of habeas corpus is the way to go. Okay, so I'm going to leave this link in the video, all right? Hopefully this video helped you guys. If you need to reach me, my email is rick0327@me.com. Happy New Year, guys. I hope to see everybody in the new year, and hopefully we're going to prevail. I got information yesterday that I had another guy have a dismissal in Brooklyn family court. He had a dismissal. Sadly, it wasn't with prejudice. It was without prejudice. So they're trying to take him back to court again. So he's had 3 months of freedom, but they're trying to pull their horse shit again. But it's still a dismissal. So it was another victory. Okay, that's why, you know, it happened to me. I was, you know, the judge issued, he stayed the order and telling the child support agency to stop, and they still kept doing it. That I did the video where I had to actually physically take a train into Manhattan, and there's that video where I'm dealing with that African woman with the heavy accent who, even with the order in her hand, she's like, I don't know what you're trying to do. I'm not even going to do her accent. And I'm like, well, it's not what I'm trying to do. It's what the judge is doing. They were ignoring it. So we're dealing with some very vicious people. Okay? But, so, you know, there's some other channels out there that will tell you you got to fight child support agency. If a child support agency is going to go out of their way to ignore a court order, how are they going to listen to something you're going to say? Listen, I got them to stop because, you know, when I told the judge fixed it. Okay? But wouldn't you rather have a judge on your side? You think the child support agency is going to actually listen to you? No. We're dealing with rotten people. You know, they're really vicious people. It's human nature. You give people power, oh, you're going to see the worst in people. You know, I mean, I told you I was a police officer. I worked at a paramilitary organization. And I work for like people who are, you know, sergeants who are over. And let me tell you, I work with some of the biggest jerk-offs on the planet. They got a little bit of power. And that guy's messing with me. He would never dream of messing with me. I used to say to a guy, if you and I were in a bar right now, you wouldn't even dream of looking at me cross-eyed. Because I'd smack the shit out of them. That's a fact. But they got a little bit of power, and they're going to use it. They're bullies. We're dealing with bullies. I don't know about you. When I was growing up, this whole campaign in this country right now, they're trying to turn everybody into wimps. The only way to deal with a bully is to punch a bully in the nose. That way the bullies are going to move on to the weak. Okay? You fight back, they're going to move on. And that's what we're doing. We're fighting against bullies. All right, so listen, again, Happy New Year, and I'll talk to you guys in the new year. Goodbye.